judgment in the matter of Ammori and the Secretary of State for the Home Department.
Thank you, Mr Hussain, Mr Watson. We are in a position to deliver our judgment in writing. The judgment will carry the neutral citation number 2025 EWCA Civ 848, and it will be posted on the National Archives in the normal way, but I suspect that that won't happen tonight. We will be distributing a copy of the full written judgment at the end of what is going to be a very short oral summary. I make it clear that the oral summary that I am about to give is not in any way in substitution for the judgment of the court, nor does it form any part of the judgment. I'm simply giving a short oral summary for the benefit of the public and the parties immediately. I hope that's clear. To repeat, the judgment is contained exclusively in the written document, copies of which will be available in hard copy at the end of this summary and in the normal way on the National Archives. By way of introduction, we say in our judgment this is an application for permission to appeal against decision of Mr Justice Chamberlain refusing interim relief. The application is aimed at preventing an order of the Secretary of State for the Home Department adding Palestine Action to the list of proscribed organisations under the Terrorism Act 2000 from taking effect tomorrow. Palestine Action is a group or network formed about 5 years ago which is concerned with taking action against companies and institutions in the United Kingdom which are said by them to be involved in what Palestine Action consider are violations of international law against Palestinians. Members or supporters of Palestine Action are accused, amongst other things, of breaking into a RAF base in the early hours of the 20th of June 2025 and damaging 2 military aircraft. Following that incident, on the 23rd of June 2025, the Secretary of State announced that she had decided to proscribe Palestine Action. The order was laid before and approved by each House of Parliament on the 2nd and 3rd of July 2025. It was made by the Secretary of State today, the 4th of July 2025, and so comes into force tomorrow, that is to say after midnight tonight. The claimant, Huda Ammori, is a member and founder of Palestine Action. On the 27th of June 2025, she commenced a claim for judicial review of the decision to proscribe Palestine Action. Following a directions hearing before the judge on the 2nd of July 2025, there is to be an oral hearing of the application for permission to bring that claim in the week commencing the 21st of July 2025. At the same time as commencing proceedings, the claimant also sought interim relief, preventing the making of the order until the outcome of the claim for judicial review. In summary, the relevant principles governing the grant of interim relief are the well-known principles set out in the House of Lords case of American cyanamide. The judge considered the interim relief application at a hearing today, Friday the 4th of July. He refused the order sought in a written judgment handed down at 5:30 p.m. and also refused permission to appeal and a stay pending the outcome of any renewed application. The claimant now renews her application for permission to appeal before us. Permission to appeal may be given only where the court considers that the appeal would have a real prospect of success or there is some compelling reason, some other compelling reason for the appeal to be heard. The application came before us on an urgent out-of-hours basis at around 6 p.m. We received written grounds of appeal at around 7:35 p.m. and heard oral submissions for an hour commencing at 8:05 p.m. This judgment is being delivered at around 10:25 p.m. Before addressing the specific issues on this appeal, we make the following preliminary observations. First, the role of the court is simply to interpret and apply the law. The merits of the underlying decision to proscribe a particular group is not a matter for the court. That is a matter under the relevant Act of Parliament for the Secretary of State, who is accountable to Parliament for the decisions that she makes. Similarly, it is not a matter for this court to express any views on whether or not the allegations or claims made by Palestine Action are right or wrong. This court is simply concerned with applying the law laid down by Act of Parliament and the principles of law developed by the courts. Secondly, this is an application for permission to appeal against a decision of the judge refusing interim relief. The role of this court on appeal is not the same as the role of the High Court at first instance. We do not sit to hear the case afresh or to substitute our own views for those of the judge. Our role as an appellate court is limited to determining whether the judge erred in law or whether his decision was one that was reasonably open to him. See the judgment in this court in the case of PCSU. In our judgment, we then set out the legal framework, we set out the factual background to the appeal, we set out a summary of the judgment below, and we set out a summary of the grounds of appeal. We then turn to our analysis, which we begin by setting out the relevant principles of law. And after that, we make our assessment of the judge's decision. Given the available time, our reasons must of necessity be short and limited to the central points as we understand them. There has been no challenge to the judge's approach in principle on the question of balance of convenience in cases such as this involving national security. The judge followed that set out in AG against BBC and summarised in the case of FTDI. Where one of the public interests is national security, the court must show great respect to the judgment of the executive about whether the relevant risk is made out and about the weight to be attached to it. In many cases, it may be difficult to find interests sufficiently weighty to outweigh the public interest in national security. Grounds 1 and 2 can be taken together. Both seek to attack the judge's finding in paragraph 98 of his judgment. Paragraphs 97 and 98 of the judgment are set out in our reasoning. It is said that the judge was wrong not to accord significant weight in the balance to the interests of those who deliberately flouted the law. The criticism is misconceived. First, as the heading of the material section reveals, the judge expressly approached the question of harm on the basis that the claim later succeeded. That is clear from the heading of the material section of the judgment and is also implicit or express throughout the section. See, for example, also paragraph 101. It is trite that an order that may in due course be set aside is nevertheless there to be obeyed until it is set aside. The judge was entitled to take the view that the harm identified, including criminal liability with associated consequences, would be the product of an individual's decision not to comply with the order, and so to be given only limited weight. Secondly, there was no failure on the part of the judge to recognise the application of Article 10 and 11 rights. Paragraph 98 of the judgment needs to be read with paragraph 97, where the judge explained that it will remain lawful for the claimant and others, quote, to continue to express their opposition to Israel's actions in Gaza and elsewhere, unquote. What will be prohibited is particular activity supporting a prescribed organisation. The judge rightly said that if, quote, individuals choose to continue to express their support for PI or PA or do the other things, unquote, identified earlier in his judgment, this will incur criminal liability. The short point is that if the harm envisaged is to occur, the claimant or others will have deliberately chosen to express their support for a prescribed organisation or to commit one of the other offences. As for ground 3, the claimant submits that the judge erred in rejecting the application in circumstances where the Secretary of State failed to provide any evidence that there was any urgency. She had been told in March 2025 of any alleged risk and had had ample opportunity to provide evidence, including again this morning. The submission is in effect that the balance of convenience should take into account the lack of prejudice arising from the short period of delay resulting from the grant of relief, or of interim relief. There is no merit in this ground. The judge was well aware of the chronology, including that Palestine Action had been active since 2000, and the decision to prescribe was based on an assessment first made in March 2025. He addressed the suggestion of delay at paragraph 95, giving it, quote, some weight, unquote, but concluding that, quote, suspending the effect of the order even for a short period would deny the public important protections which the order is intended to confer, end quote. That conclusion is unimpeachable on appeal. We note also that the Secretary of State acted promptly and with urgency following the immediate trigger event of the 20th of June 2025. Ground 4 has a number of strands which we address as follows. First, it is said that the judge assessed the balance of convenience by reference to evidence that might be adduced in the future, rather than by an assessment of the evidence before the court. That submission is based on paragraph 73 of the judgment, where the judge said that it was difficult to evaluate the strength of the challenge based on Articles 10, 11 and 14, particularly as later evidence might put a different complexion on the arguments about proportionality. It is said that he should have assessed the strength of the current evidence. In fact, when the judge considered the balance of convenience later in the judgment, he did not rely on the possibility of further evidence emerging. At most, he bore, quote, in mind the merits of the claim on the basis of the evidence at this early stage, end quote. Then it is submitted that the judge failed to have regard to a number of factors, including the chilling effect of any order, the effect on employment, education and liberty, the fact that the order was insufficiently clear and might lead to people self-censoring or inadvertently committing criminal acts. In fact, the judge identified all the relevant considerations. See his careful analysis at paragraphs 96 through to 101. It is further said that it is wrong to penalise some because of the actions of others. It is said that if some Palestine Action supporters engage in violent acts, that does not justify the taking away of the rights of others. The position is, however, that no person will be penalised in respect of conduct prior to prescription. People may only be prosecuted and punished for acts in which they engage after prescription comes into force. Furthermore, they will still have the rights to lawful protest, as the judge recognised in paragraph 97. The claimant referred to other disparate matters, including the fact that even a short period of prohibition may give rise to a violation of a convention right, and that the timing of the ban may be relevant, relying on Christian Democratic People's Party against Moldova. None of these matters on the facts of this case, however, causes us to think the judge made any relevant error. We note that the Christian Democratic People's Party case arose on very different facts. In short, none of the points raised in Ground 4, either individually or collectively, have persuaded us that there is any arguable error on the part of the judge. Ground 5 criticises the judge for finding that the availability of an appeal to POAC was a hurdle which the claimant would in due course have to surmount. In fact, the judge said only that if the Secretary of State's alternative remedy was a good one, it may provide an answer to all of the grounds. All the judge noted was that if the Secretary of State's ground was a good one, it might provide an answer to all of the claimant's substantive grounds. It is difficult to see why that was an error of law, and in any event impossible to see that the comment had any material impact on the outcome of the balancing exercise. Fundamentally, the judge identified all relevant factors and weighed them together in the balance, according significant weight to the public interest in national security, as he was not only entitled but right to do. He recognised that this was a case, quote, involving those who use or threaten action which involves serious damage to property, but do not target or aim to endanger people, end quote. He noted that the explanatory memorandum indicated that the activity was increasing in frequency and severity since 2024 with more aggressive methods. He was entitled to conclude that some of the fears and potential consequences of the order had been overstated by the claimant and others. In short, there is no basis for appellate interference with the judge's assessment that the balance of convenience lay in favour of refusing interim relief. In conclusion, we have identified no arguable error of law in the judgment, nor have we found any arguable basis for a finding that his decision was not one open to him on the facts and the evidence. For these reasons, we have concluded that there is no real prospect of a successful appeal and no other compelling reason why an appeal should be heard. Permission to appeal is thus refused. Finally, it would be wrong for us to leave court now without repeating our thanks to the court and the administrative staff and our clerks who have made this evening's hearing possible. Any corrections? Yes, forgive me. Thank you very much. My Lord points out that at one stage I said Palestine Action had been active since 2000. It should have been 2020. And I have spotted a few. I will allow the distribution of the written judgment as it stands, but there are a few gremlins that I will correct before it goes up electronically. But nothing, I think, substantive. Nothing substantive.
My lady, thank you very much. I may have apprehended. I'm instructed to make two applications. Firstly, an application for permission to appeal to the Supreme Court on a point of general public importance. The issues in this case are of general public importance. The question of law is whether on an interim relief application, when considering balance of convenience, it is legitimate to regard as operative the general rule that an executive order has legal effects until set aside in circumstances when the premise is required to be that that order is unlawful. That's the immediate ground we'd identify.
Well, I think I'll have a quick discussion, but I think that
Yes.
drafting on the hoof is not really going to work. You're not going to get to the Supreme Court before midnight. So I would suggest that perhaps if you want to make an application, we should do it in writing on Monday. Yes, do it in writing on Monday.
Do they have jurisdiction?
Yes. We think that the sensible thing is for you to submit any application you wish to make by 4 o'clock on Monday. My Lord Justice Lewis would want you, in the first instance, to address the question of jurisdiction in circumstances where we have refused permission.
You're right.
So have a look at that and make any application for certification and permission that you want to, but by 4 o'clock on Monday.
All I can say is it's very late.
Yes,
But I think you're right.
not too late for my lord.
The other application I wanted to make, if I may, is for a stay pending our application.
Yes. I mean, no. No stay. Thank you.
Very much, my lady.
Thank you, Mr. Hussain. You've carried out your instructions to a T and done so with great courtesy. So thank you for that. Mr. Watson, do you have any submissions to make?
Only an application for cost to be reserved.
Cost reserved. Yes, that seems sensible. Anything else? No. I don't know whether enough copies have reached everybody. I'm glad. Could I, just because I'm here, could I make a few manuscript alterations? Just so I get nervous. Paragraph 2, line 5 should be Palestine Action. Paragraph 7, last line, page 3, some other compelling reason. Yes? Yep. Paragraph 8, 1025, not 1015. It's probably the most important point of the evening. My Lord's correction to
42.
paragraph 38, there's a gap, line 3. Paragraph 40, bottom line, from the grant of interim relief. See that? And then paragraph 41, 2020, not 2000. Paragraph 47, ground 5 criticises the judge for finding that. Take out that the judge erred in considering. Yes, thank you. Paragraph 45, the citation from Moldova, there's a paragraph bracket, not a 0, and it's, what's that?
That was a bracket in the wrong place.
Bracket in the wrong place, yes. Thank you.
I think there's a repeated sentence, isn't it?
paragraph 47. Yes, I may have repeated myself. That's a good point. Could we just take out the sentence, all the judge noted was that if the Secretary of State's grounds was a good one, it might provide an answer, because I am, unlike you, Mr Hussain, repeating myself. And I think that is it.
We need to add a couple of paragraphs from the judge's judgments.
Yes, paragraphs 97 and 98. Yes, paragraph 35, I need to add in paragraphs 97 and 98 in the judgment. Thank you. Would somebody be kind enough to draft an order for Monday, perhaps to submit by 4 o'clock, an agreed order on the appeal?
Just one matter, my lady. If we find out that my Justice Lewis is correct, then presumably, do we need to do something? Or do we just confirm the position?
Yes, either a nil return or an application, please. Thank you very much indeed.
My lady, one very minor matter, and I
Yes, of course.
hesitate to rise to raise it, but I'm very grateful to the court staff for attempting the fathers on my name. The one on the A is in the wrong direction.
No, that really matters. Your name is beautiful, and I'm very keen to get it right.
I'm very
What have we
grateful,
got
my lady.
wrong?
So the accent, the father on the A of Crawley should be the other way
The other
round.
way.
Thank you.
Don't worry.
In French, that will be an accent aigu.
Aigu, indeed.
Yes. Look, you've all had a long day, and it's hot in here. It is the best of the bar on occasions like this. The courtesy and the endeavour is self-evident on both sides. We are very grateful to you. I have thanked the staff and the clerks. I would also thank my lords for stepping in at very short notice, at not inconsiderable personal inconvenience. Thank you all very much indeed. Thank you so much, Ross.